Supreme Court's July 11, 2024 judgment includes far-reaching decisions that will significantly alter local government administration in the country. The Supreme Court has affirmed the financial autonomy of Nigeria's 774 local governments. In a unanimous judgment of its seven-member panel on July 11, the Supreme Court unanimously upheld the suit brought by the federal government to strengthen the independence of local governments in the country. A member of the panel, Justice Emmanuel Agim, who delivered the court's lead judgment, held that the local governments across the country should, from July 11, receive their allocations directly from the Accountant General of the Federation. He ruled that it is illegal and unconstitutional for governors to receive and withhold funds allocated to the local government areas in their states. He ordered immediate enforcement and compliance with the orders of the court by the state governments and successive governments henceforth. Today, we'll be discussing an important part of this judgment, and that is the local government tenure elongation by the Supreme Court. The judgment partly reads, under Section 135, subsection 3 of the Constitution, the tenure of 4 years for the President provided for by Section 135, subsection 2 thereof, shall be extended for periods not exceeding a period of 6 months at any time by a resolution of the National Assembly if it is not practicable to hold elections. By same token, by a law of a state house of assembly, the tenure of local government councils can be legally extended for any reason, such as insecurity or war, if it becomes impracticable or impossible for elections into the local government councils to be conducted. The mandate given to an elected local government council is the mandate of the electorate of that local government area. And if the tenure is extended, it is the people's mandate that is extended. If the tenure of a local government council is truncated, as it is the norm now, it is an illegal termination of the electorate's mandate, and it is not to be encouraged, but roundly condemned. Honorable Olaka, what is your take on this story?
I would have declined comments.
Okay.
On this issue.
Okay.
Because there are plethora of cases which are subjudiced. I'm not a lawyer, but I do know that matters that are in court or before the court, we shouldn't be talking about and all of that. But the issue that it affects Rivers State, the local government autonomy is not about Rivers State alone. Because Rivers State is not the only state that has that was going to be affected by that Supreme Court judgment. It is an issue that concerns the entire nation. Having said that, you see, the law in Nigeria and any part of the world, it's not something that any individual should try to make it valuable for his own benefit or immediate benefits. That has been one of the problems we're having. In Rivers State, on the issue of tenure elongation, I agree with the Supreme Court judgment. Okay. That where it is impracticable to hold election as the law provides, there should be elongation, but it has to be the product of the activities of the assembly. Mm-hmm. Okay? But there are exceptions as far as Rivers State is concerned. Okay. What is it that has made it impracticable for the local government election to have held in Rivers State? Is an issue. That's not the issue that was discussed in Supreme Court. Mm-hmm. That which has made election not to be practicable in Nigeria. In Rivers State, within that time, mm-hmm. when the tenure of the government, the council chairman was to elapse, it's not the issue at Supreme Court. It's about the tenure elongation. Now, in Rivers State, mm-hmm. What was the position of the State Assembly, mm-hmm. as at the time prior to when the tenure of the council chairman would elapse. Who was the what do you call it? The Speaker of the House is subject to litigation and has still been an issue of contention because of the political crisis in the state. Whereas you have the Martin Ameule-led executive as House of Assembly, as they claim, led House of Assembly. You have the Edison here led House of Assembly as it were, and then fast forward to Victor Oko-Jumbo led House of Assembly, you know, and then within the period we also have the issue of defection. We have the Martin Ameule from PDP to APC. It was done in the floor, it was in the glare, it was in the news, video evidences here. Nigerians, Rivers people, we watched and we saw and open. And then there is a position of the law with regards to defection as it has to do with the legitimacy of the seats at that point. Going back, we also talked about, we're also aware of the court order that mandated or empowered Edison Ehie's a position as the Speaker, therefore heading toward declaring the seats of the people, the defectors, vacant. Within that same period, the issue of the amendment of the purported law, local government, that talks about the local government elongation.
No, that was after Edison Ehie had resigned and became
Victor
Chief of Staff.
Oko-Jumbo.
It was between Edison, Victor Oko-Jumbo and Martin Ameule.
Now, that's what I'm saying. And so, when you look at the entire drama, you will agree with me that the judiciary is sick in a way. And if you put all of this together, you cannot, at this point in Rivers State, begin to drag down the Supreme Court judgment to be practicable here. I mean, enforceable here in Rivers State. What is in Rivers State is that that should have been a lacuna. But nature itself abhors vacuum. And so there are people taking care of the council at the moment, and it is enforceable and empowered courtesy of the operations of the Rivers House of Assembly led by Victor Oko-Jumbo.
It's okay. Now, if you say there are people taking care of the council, in this instance, that's
a caretaker committee chairman.
Now, are you saying that a Supreme Court judgment that was given and the order was that it is to be implemented with immediate effect? Are you saying that the Supreme Court judgment doesn't have weight to the actions in comparison to the actions of Oko-Jumbo led House of Assembly? Because if you're saying that the caretaker chairman as screened by Oko-Jumbo, right, are taking care of the council, it's acceptable. But the Supreme Court had ruled that it is illegal and even went further to say that their allocations should be seized by the federal government and not paid to them. Are you saying that their continual stay is not a case of being an impostor? Are you saying they are not impostors by the law? Are they recognized by the law as it stands now?
We would not narrow the Supreme Court judgment and pronouncement to Rivers State.
Now, you know, you have brought in, you've talked about the Rivers State House of Assembly, the legislature.
Yes.
And you said it cannot be narrowed down. I have not asked you questions based on that yet. Now, from there, you have moved from the legislature.
Yeah.
And you have moved to a third tier of government. There is a clear movement, transition now.
I agree with you.
So when you say that law cannot be enforceable because you are questioning the authenticity of the House of Assembly that's repealed and also enacted and amended the law.
Take this from
you said it cannot be enforced.
Take
now,
this from
hold
me.
on.
All right.
Now, you have moved from there to the third tier of government.
Yeah.
And you're saying that the caretaker chairman should be allowed to run regardless of the Supreme Court judgment. You say it cannot be enforced in Rivers State because Oko-Jumbo has already screened them and they are qualified to be caretaker chairman, so they should be allowed to stay.
Good.
Make it make sense.
Because why I'm saying this is look, the Victor Oko led Jumbo House of Assembly had not considered any law that has to do with tenure elongation in Rivers State.
But they also screened this caretaker chairman
before the Supreme Court judgment.
All right. Now, are you aware that there was an appeal court judgment?
Okay.
Are you aware?
Which one in particular?
The appeal court judgment with respect to the jurisdiction and the judgment of Justice Wali. And you are aware that it was Justice Wali that authenticated the speakership of Okojombo.
Okay.
And appeal court came out to make a nonsense of that judgment. And the appeal court said that the High Court, Rivers State High Court, in fact, state high courts, let me make it wider. State high courts do not have jurisdiction over issues pertaining to the state governor, state houses of assembly, as it were. Right. And they now said, by that statement, every judgment, orders, rulings that has been embarked upon by Justice Wale of Rivers State High Court is a nullity. Okay. And the appeal court further went to say that in the speakership of Honorable Martins Amehule, that is not even in contention. Are you also aware that there was a judgment by a federal high court in this instance? That is the federal high court by Justice Omotosho, that recognized Martins Amehule as the legitimate Rivers State House of Assembly, and also mandated the governor and every other person to deal with them and recognize them as such. And also, part of the judgments by Justice Omotosho was to cancel the budget presentation to Edi Sinehe and mandated the governor to represent the budget. But that's not what we are discussing now.
Okay.
And that particular judgment by Justice Omotosho has not been appealed. It has not been vacated.
Okay.
So that judgment is still subsisting. Now, if you bring in the judgment of Justice Danagogo, now the question will be jurisdiction, because Justice Danagogo is of the State High Court.
Okay.
Now, some people will say that judgment has not been vacated. But then, when you look at it critically, it was authenticating the speakership of Edi Sinehe, who has already resigned and is currently the Chief of Staff. If the judgment of Justice Danagogo is anything to go by, the question will be, why did Okojombo go to Justice Wali to authenticate his speakership? I don't know if you understand what I'm saying. So, as it stands, I think the reality on the ground, with all this rigmarole going on, is that the speakership of Martins Amehule, in the first place, has not been contended. It's not in contention. It has not been vacated. It has not. So, when you look at it critically, who is the authentic Speaker of Rivers State House of Assembly?
All right. I did mention that the judiciary, I use the word, is sick in a sense. And most of the problems we're having in the states and indeed the nation, the judiciary have some quarters of the blame because of conflicting judgment as being delivered by
courts of
coordinate jurisdictions. Whereas I did say that I would have declined comments on this issue because that's not the point where we should be discussing today. However, as at today, you are aware that a few hours ago, there was representation in courts, in the Federal High Courts, whereas a council representing Victor Okojombo-led assembly was in court to represent the speaker. At the same time, a council was also in court to represent Martin Amehule led House of Assembly at the same time. That matter has been adjourned to August 30th. It is still on the issue of speakership.
19th.
19th?
Yes.
Oh, good. Now, What this means is that the issue of speakership have not been laid to rest. My position here is in conformity with the response of the state government in Rivers State here.
And what is the response
Rivers
of the state
State,
government?
the Speaker of the Rivers State 10th Assembly remains Right Honorable Victor Okojumbo. And as at today,
okay,
the caretaker committee is in charge of the local governments in Rivers State.
So it is okay.
And
it is okay
until
it is okay that illegality is perpetrated.
Excuse me, you may be defining it as illegality. If
the Supreme Court has said that if the Supreme Court has said
what the Supreme Court
caretaker committees are illegal and should be enforced with immediate effect.
It is in light of that.
You're saying that it is acceptable in Rivers
Lauricia,
State.
excuse me. I am saying that in light of that, the Rivers State Independent Electoral Commission is in the process of conducting a local government election. And a date has been fixed for October 5th. As we speak, political parties who are interested in the election are rolling with the activities in line with the plan or the unveiled guidelines 2018, sorry, by RISEC, and they are in line with that. The political parties are working with RISEC to ensure that come 5th of October, election will be done, and elected local government.
And have you heard activities around the council elections from RISEC, unlike other states where you keep having updates on political parties who have submitted what?
All of that has been done. Yes, we are aware. I am aware.
Are you also aware that APC is in court with RISEC?
I'm aware that any political party can have the right to go to court in any area they are not comfortable with.
Are you aware of the details of the prayers?
I am aware that any political party has the right to go to church. But do you know the details of the prayers? I am not a party to the suit, but I am aware because I am a party man too.
Okay.
So I am aware. And the last time the IPAC chairman, Sensei Osaro Suswema, had addressed the press, he had told the people that the parties, 16, so far 13 political parties have indicated interest. They have picked the expression of interest form. They have so fulfilled the processes and have submitted. Okay. Now, RISEC has gone on inspection of the party offices to ahead of the party primaries. The last information available to me and to the political parties right now is that courtesy of the nationwide protests, the party primaries, which was originally stipulated to hold between 29th of July to 3rd of August, could not take place because of the tension around. And after the 10 days protest, we are hoping, or the parties are hoping to hear from RISEC. Now, until that happens, Rivers State local government will not be without the caretaker committee. And after that, I am sure the elected local government chairman will be known after 5th of October.
And that also opens up another plethora of conversations and questions. You know, if that's, well, is the decision of the executive. However, that still brings up another concern, which we'll not be discussing today, and that would be how is the government funding the local government councils in Rivers State? Is it coming from the state budget? When, according to the Constitution, it should come from federal moving forward. But then that's discussion for another day. And that might be viewed as constitutional infraction, by the way. But then, Ifeanyi Chukwu, what is your take on this development? Supreme Court judgment on tenure elongation. I want you to marry it with the issue going on in Rivers State. The judgment of the local government law by Martin Amehule led Rivers State House of Assembly.
Laurentia, thank you, and also thank you, Honorable Olaka. And this is an academic discourse because it involves a lot of, patches of judgments and litigations still ongoing in Rivers State. So I just pray I have the floor to really, try to compress them together to make a lot of sense. And I will start by going through the concluding part of the judgment. The concluding part of the judgment by the Supreme Court, because in this case, I want to speak on the meat of the matter, but I want to say what they have said after the whole 20-page or 30-page. I don't know how many people that have read that the judgment, but one of the justices that read out the judgment said that the Supreme Court judgment reads in parts. It is for all the foregoing reasons, the more comprehensive reasons advanced by his learned brother, I think the person he compiled the judgment with, and he himself, the led justice, find that this action, that is the action of the plaintiff, which is the federal government or the Attorney General of the Federation that went to court for the autonomy of the local government, the case they instituted, he said he finds the action or the suit to be very meritorious, emphasis, to be very meritorious. And he said that he answers all the questions in the originating summons in the affirmative. That is, he is, in conformity with what his learned brother has said, that all the case, all the letters of the plea that was brought before them, that have gone through it, and he is also concurring in the affirmative to say that what they have adjudicated has an effect in the positive. After saying that, he said that he is in favor that, and in the favor of the plaintiff, and they granted the declarations and the orders as set out in the leading judgment. That's all the judgment that have compiled. And at the end, he said that all the parties are ordered to bear their cost respectively. So the Supreme Court justices were in conformity that when they have gone through the litigations of some of the letters, of some of the things I will mention now, that they have found that the weight of the case that came to them are very, very meritorious. And they have affirmed that there is positivity in the case that was brought up before them. What is the case that went to the Supreme Court? They, having seen all the shenanigans that is playing out in the Nigerian political space, not exonerating any of the governors. Only few governors in Nigeria maintained the tradition of conducting elections into their local government areas. Since 1999, when the Fourth or Fifth Republic came till this moment. And the federal government has also gone to the Supreme Court in one or two occasions in trying to, enforce the autonomy of the local governments. And the last one was also laughable, that when it required the two-third approval of the state houses of assemblies, they also refused to let it fly. They refused because I think it remained one state for them to get to the two-third, and they couldn't get at it. And today, that is why the President Bola Ahmed Tinubu's administration has also looked at it, because he was also a governor and who fought for the local government autonomy that led him into creating LCDs in Lagos. That is why he understood what the local governments have been suffering. And before Bola Ahmed Tinubu came, there is also a Martin Samehule whom we will call, if you go through the letters and the writings of the Supreme Court judgment, you will say that he is a visionist in the category of politicians in Nigeria. He is an astute politician, and he also, looks into his crystal ball and has the interests of the people at heart.
What makes you say that? Because
what the federal government has gone to pray in Supreme Court is what he did in the amendment of the Rivers State Local Government Law 5 in March.
But then the Supreme Court also gave, the Supreme Court said when it is impracticable or impossible to...
And he also said it, I'm coming there. You will also see the mention of what the Supreme Court said and what Martin Samehule said on the day the bill for the amendment of that said. So the Supreme Court, let me come from the Supreme Court first.
Because of your time.
Yes. The Supreme Court, said that in the case that was brought before them, the local government autonomy, that they have watched the governors recklessly and in flagrant disobedience of the letters of the Constitution, refused the local government to have their financial autonomy. Because you remember that the JAC is the port that controls the finances.
Tenure elongation.
No, the finances is also the originating someone. I'm coming there, Laurentia, and they say that the finances that are given to the governors are being misused by the state governors, and that gave a leg to the tenure elongation. And the tenure elongation, they say that if the INEC, which serves the federal interest in conducting national elections, refuse to conduct the election into the houses of assembly and the governor's seats, how will the state fare? But the governors, because they have been given the power, and those powers are embedded in the powers of the state houses of assembly, as acknowledged by the Supreme Court. The Supreme Court said that the powers, look at what the Constitution said. Section 7(1) of the Constitution of the Federal Republic of Nigeria said that the local government system shall be run by elected council, by elected councils, and Section 8 of it states how the states shall be subject to this section as it concerns the structures, composition, finances, and structures of the councils. This is the powers that the Constitution gave to the state houses of assembly, where Martin Samehule and his brothers drew their power in the amendment of the law number 5 of the Rivers State local government laws. It is from the Constitution. So this goes to nullify what Justice Wale said, that the amendment that Martin Samehule led assembly carried out was inconsistent with the Constitution. And the question now I ask is, which Constitution? This Constitution has granted the powers of making laws for the good governance of the local governments into the hands of the state houses of assembly. And it is only for the governor to execute. So Martin Samehule now drew his powers from this to amend the River State local government law number 5. Okay. And in that local government number 5, on the said day of when they were debating on this, the amendment of the River State law, before that, members of the House contributed to the bill, describing it as essential amendment that will engender emphasis, that will engender smooth and uninterrupted democratic administration of the local government level. And when they came to this, the Supreme Court has also said that if it is impracticable from the section 135(2) of the 1999 Constitution as amended, say that where it is impracticable for an election to be conducted, that the House of Assembly, which the Rivers State House of Assembly is also a party to, has the powers to elongate the tenure. And this particular thing is what is happening in Ukraine. Ukraine is at war, and Zelensky's tenure has expired. Remember that before 2023 general elections, there were accusations and counter-accusations flying around that Muhammadu Buhari might use the crisis that was brewing in Nigeria to call that Nigeria will be governed into a state of anarchy, where the National Assembly may be forced to elongate the tenure of Muhammadu Buhari. Those rhetorics, we saw it fly, and in Israel today, it is the same applicable. And the 1999 Constitution of Nigeria as amended captured it. The people that framed the Constitution had in mind that a sitting government might be in power, there may be a war, there may be an unforeseen circumstances that may make it impracticable. During Jonathan's time, it happened. You find out that the elections were shifted because they wanted elections to be conducted in some parts of the northeast and northwest, and Jonathan had to go through the National Assembly or through the INEC to extend the time in which the election would have been conducted by 1 month, so that the military will be able to clear some remnants of Boko Haram for elections to be conducted. And in this case, in the case of Rivers State, like Honorable said, the case of Rivers State is that war is...
What war?
In the case of war or unforeseen circumstances, that will now lead to the extension of a sitting president or governor or local government chairman, as the case may be. In the case of Rivers State, when he said that it is different, it is not different, because the governor of Rivers State, Simon Fobola, came 2023, and he's also aware that he's entering into an electioneering year, 2024. He will not say that he didn't know that in the budget, when I started suspecting that the election will not be conducted, was
the local government elections
was when the purported budget was presented, and there was no capture of the monies to be expended by RISEC in the conduct of local government elections. Because
so
the
where
governor
is the money coming from now?
That is what I'm saying. The governor was well aware that he's going into a local government electioneering year in 2024. He did not make provisions for that particular execution of the local government elections. That is one. And when you look at it critically, you find out that Martin Samehule, who had then drawn his powers as the legitimate and authentic Speaker of the Rivers State House of Assembly by the judgment of Omotosho on January 22nd, 2024, clearly stated that the Rivers State government should not interfere in the activities of the Martin Sameh-led House of Assembly, that the governor should stop forthwith in the further demolition of the State House of Assembly. The governor should not interrupt with their finances as enshrined in the statutory allocations, and that again that the governor is not the person that will give them a place to sit. That the Rivers State House of Assembly has their statutory powers to choose where they sit to make laws. And that particular judgment, like you said in your expose, has not been vacated. Nobody appealed it till today. And when the Rivers State government went to court in order to authenticate whether Martin Samehule had defected or not defected, which we have had the court say that defection in the caliber of their political position is not to be seen on the newspapers or on the television. No.
Justice said that?
Yeah, there are practical ways.
Who said that?
I cannot remember the...
Justice Bassam.
Justice Bassam.
When he denied jurisdiction.
He said that even in the denial, he also said something that is very apt, that for the people of their caliber who hold political positions to really defect, there are processes. They have to write to their ward chairman, to the state chairman, and ask the question, if you go to the wards of these 24 or 25 lawmakers now, have they really written to their local government, to their ward chairman, indicating their intentions to defect from their parties? The answer is no. If you go to the same ward level, will you see the name of Martin Samehule in the register of APC in his ward level? The answer is no. So when you come back to the meat of the matter, Martin Samehule said on the day...
the meat of the matter.
Yes.
Your time is almost...
No, Chomasi. Martin Samehule said, Laurentia said, noted that the amendment on the very day that they were amending the bill on the local government, he said that the amendment is to ensure, in the words of Martin Samehule, ensure that the local government election are conducted before the expiration of the tenure of any outgoing local government administration. This is apt, and you will see it in what the Supreme Court said. So I'm marrying it with the extension of the local government tenure in Rivers State, and the position of the Supreme Court and the position of the Supreme Court of Nigeria. In their position of, they say that the state houses of assembly has the powers to elongate the power of the local government chairman, and that particular mandate is not being truncated. Because remember that those people that their tenures will be elongated are also elected. They are still carrying the mandate of the people into the extension of the 6 months. And that 6 months again, if there is no visible time, I think the law will also provide for the lacuna that is unforeseen.
All right.
And in this case, you will also remember that in trying to amend this particular law in Rivers State, the Martin Samehule led Rivers State House of Assembly wrote to the governor, and after the amendment, they also gave the governor the latitude of time to sign it into law. And when he refused, they went through a process, and they asked the process of how the seats of Martin Samehule and his brothers were declared vacant. I also asked the process of the passage of the Rivers State budget. I also asked the process through which the commissioners, that are the people that call themselves commissioners in Rivers State, are being screened. Because if you look at the presentation of the bill on the amendment, after the presentation, Martin Samehule ordered that the House be resolved into committees to look at the meat of this particular amendment. And when they find out that it is apt, they went into the practice. So I disagree with anybody who has a divergent view, though they hold their own opinion. But according to what the Supreme Court has said, and according to the Nigerian Constitution 1999 as amended, the state legislature, which Martin Samehule remains the authentic speaker, has the right and the privileges as embedded in section 7.1 of the 1999 Constitution to amend that particular 2008 law of Rivers State, 2018 law of Rivers State local government autonomy, in order to, extend the tenures of those outgone local government chairmen.
The question would be, now, there is already provision for that to even happen. It's not like state houses of assembly can just at their own behest, extend tenure of council chairmen. Now, there is a provision, and he said, but then he said for any reason such as insecurity or war. Rivers State does not have war, or are we in a war?
No, but I've said that what brought about the Rivers State, the repeal of that particular local government law, is because of maladministration. My brother made mention that why Nigerians are protesting today is part of it is maladministration, because the governor has refused to do the needful. And you know that for a governor to be impeached, there will be a letter that will say that this particular governor has really breached the constitutional provisions inherent in his office. That is in the eyes of the legislature, that is considered as misconduct, a gross misconduct. So the governor who came into power and knew that there will be a conduct of a local government elections in his handover note and in his briefings, and he was part of the former administration of Nyesom Wike. So he will say he did not know.
All right.
And now, when he has refused, it is the governor and his handlers who shot themselves on the foot.
All right.
Because they have refused to take the window. Because the election process the governor had about 6 months to start in the 3rd month to start conducting elections. But whatever be the case, best known to him, and it has that made him not to take advantage of the window to conduct those elections is left to him. But this, in comparison, Lauricia,
hold on, you will still come back to that.